and due for the sake of due process, and I think
Sorry,
that's kind of what
that's a word salad. It's not making any soup.
shoulders. I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used. And I, the man speaking with a voice and
Okay,
a
so
sound
I'm going to
mind.
cut this off. What is a preliminary exam?
Well, before I address that, may I address
No,
it to
sir.
you?
No, we're gonna focus our answers here.
This sovereign citizen just learned the hard way why you should always get a lawyer. This dude literally told the judge is not the name on the charge is Shoulders. Yeah, you heard that right. Shoulders, if anyone out there can explain how a grown adult ends up thinking that's a real legal defense, please drop it in the comments, because I seriously need some answers. The judge looks stunned. The defense attorney gives up halfway through, and the whole courtroom feels like it's stuck in an episode of Dumbest Legal Theories Ever. I swear, do all sovereign citizens read the same conspiracy blog, or is there some secret Facebook group passing out these scripts either way? This one gets real heated, so let's dive in and watch this guy make a complete fool of himself.
May I have appearances for the record, please? Mr. Nitz?
George, thank you, Andrew. George Nitz, on behalf of the people.
Thank you. And Mr. Thornton, could you state your name for the record, please?
I am Shoulders in here by way of executive office for Latavia State Thornton nonprofit organization.
Except that as Mr. Thornton announcing his appearance before the court. We are here this morning for a pre-exam conference. Mr. Anid, it is my understanding that Mr. Thornton has declined representation. However, Mr. Thornton, at every appearance, I need to remind you that you have a constitutional right to be represented by an attorney, and that if you can't afford an attorney, the court will provide one for you. I am particularly proud of the superb public defenders we have in this court. However, you may also retain any attorney you wish. You will get to choose the attorney. You would have to pay them. You have a constitutional right to represent yourself, but I have to warn you that if you proceed representing yourself, you would be held to the same standard as all attorneys who have gone to law school, passed the bar, and been admitted to practice. So the court really can't give you any breaks or help you at all. Is it your wish to represent yourself, sir?
Mr. Thornton is aware of the courtroom decorum and the standards and procedures that must be upheld by a person in representation of a party. And as again, Shoulders, I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used, and to uphold the proper standards. Mr. Thornton does not wish to get public counsel representation as I am a legal representation by special appearance through the executive office for Mr. Thornton and not the actual entity, Latavia State Thornton. Once again, on the record, it has not been declined that Latavia State Thornton is a nonprofit organization, which, yes, Your Honor, is a person, in fact. And I, the man speaking with a voice and a sound mind.
So I'm going to cut this off. I don't want to mute you, but we have to move forward. We have an attorney standing by. That would be Mr. Foreman. Have you had an opportunity to speak with Mr. Thornton about any plea offer?
No, Your Honor, and I don't think I'll have any meaningful conversations with him based on what I see. I believe that it's not clear whether what he's doing is intentional or whether this may be a competency issue. But I'm prepared to proceed. I just don't know if we should. I have a concern for his competency, to be honest with you. If the court we had the same issue this time.
No, Mr. Thornton, one person at a time. And right now, Mr. Anid is speaking.
I mean, I guess I would inquire with whether he knows what a preliminary exam is, and if he understands, if we forward. if he's going to know what to do. I mean, I believe I have to look at the court rules. I've never dealt with this issue, but I think having standby counsel would be something that would be needed to advise him. I'll look into all that, but I just don't know if he's going to know what a preliminary exam is. I believe this may just be a competency issue. I don't know, Your Honor.
Okay, so actually that's a good question. So Mr. Thornton, I'm going to ask you, what is a preliminary exam?
Well, before I address that, may I address
No,
a few?
sir. No, we're gonna focus our answers here. What is a
Right.
preliminary exam?
Your Honor.
I'm going to give you
Your
one
Honor.
chance to answer. What is a preliminary exam?
Court proceeding. Mr.
Okay,
Thornton
and
said
what-
that.
Okay, and what happens? That's a good answer. What happens at that court proceeding?
Just have to say, is anyone else getting flashbacks to that one kid in class who definitely didn't do the homework, but still tried to fake it when the teacher called on him? Because that's exactly what this feels like. The judge just asked this sovereign citizen to explain what a preliminary exam is, and this man hit him with the longest stutter since dial-up internet. Everyone on Zoom, the judge, the attorney, even the court clerk, looks like they are fighting to keep a straight face. It's giving major, I didn't study, but I'm gonna wing it energy. Like when you're trying to do a book report on Moby Dick using only the back cover. And listen, you don't even need to be a lawyer to know this. A preliminary exam isn't some open MIC night where you rant about fake laws and demand the judge prove gravity exists. It's literally just a court checking if there's enough evidence for trial. Anyway, let's get back into it, because whatever answer is about to give next is going to be pure comedy gold.
At a preliminary examination court proceeding, the parties have the opportunity to present evidence, cross-examine each other, and determine whether whether evidence is admissible to go into continuing proceedings, whether the court has jurisdictions. A plethora of matters may be brought up in a preliminary examination to see if the court has a valid standing, to see if there's anything, to see what may be addressed that's necessary as far as the parties that are at hand, not only to go about things in a one specific fashion.
Well, that's pretty. That's a pretty good answer. However, at this point, given a review of
Your Honor,
history, the court is going to sua sponte suggest that a competency exam be ordered. Mr. Anid,
I
any
agree.
response?
I agree.
Okay, thank you. Mr.
Yeah.
Thornton, any response?
Mr. Thornton does not believe that a competency exam sua sponte is necessary and objects that as a preliminary exam is something that we can proceed to and we can address the matters and the situations that are necessary at that time. And for the sake of due process and the judicial precedence of due process, that a criminal a competency test may delay that, and it could hinder not only Mr. Thornton, but the things that Mr. Thornton does as far as the community and his career and his family and his life and rights, and other people that may be affected by this matter, as well as the public. Because for the judicial precedence is that Mr. Thornton is innocent and not guilty.
Mr. Anid, are you going to prepare a proposed order, or?
Your Honor, I think it's been a while since I've done. I believe if I'm not mistaken, it's the. I can if you want. Yes, I'll prepare an order.
All right, so at this time, Mr. Anid, comment on the preliminary exam?
No, I just say we just make the preliminary examination to be determined date. If anything, reset it for another PCC or a review hearing for when we do come back with a competency opinion.
Okay, so Mr. Thornton, you have two rights at play here. One is the preliminary exam that we just discussed, and the second is the right to have that within 21 days. So the reason that you have a right to have that within 21 days is to prevent cases from dragging on endlessly. There are certain timelines that have to be met. However, the court can waive that 21 days if it finds good cause. And that would be, for instance, if one side had recently received discovery and was unable to proceed. Another good cause could be if someone was ill or hospitalized. There could be any number of good reasons. So I'm going to ask you, actually, Mr. Thornton, have you received any discovery in this matter?
I have not. Mr.
Okay,
Thornton
so
has not
good
received
cause.
any instrument.
Okay, so all right, two things then. First, I find good cause to waive the 21-day rule, and we will get
Objection, Your
a
Honor.
date. No, sir, just a minute. Let me finish.
I'd like to
You
proceed
can't.
without
You
this.
don't. No, listen, I don't want to mute you, but I have to get through this. So, you have to have you have a constitutional right to have knowledge about your case, and if you haven't received any discovery, we can't go forward until you receive it. So, two things. First, I'm going to waive the 21-day rule. And just a minute, Mr. Ed. We're going to waive the 21-day rule, and we're going to set a date out in about a month. That'd be a placeholder date. At this point, because you are representing yourself, I'm going to allow you to converse with Mr. Anid, recognizing that you do not have discovery materials, so I do not expect this court to accept a plea bargain today. We're going to put you both in a breakout room, and when you're done, the court will be ready. Thank you.
I've got a weird feeling this isn't going to end well. And honestly, I've seen enough of these to know exactly how it plays out. Every time a sovereign citizen gets sent into a breakout room with an attorney, it's like trying to teach a cat how to do taxes. Absolutely nothing gets accomplished, and someone ends up angry. Now, to be fair, this guy isn't the dumbest sovereign citizen we've seen on the channel, but that's also like saying a soggy French fry is the crispiest one in the trash. It's still trash that you just know the attorney went in there optimistic, ready to help, and came out questioning every life choice that led them to this Zoom call. I once tried helping a co-worker with her resume, and they told me they don't believe in jobs. This feels exactly like that. T's always the same routine. They listen for maybe 2 seconds, interrupt with nonsense, and then act like they won the debate. Anyway, let's dive back in and see the attorney's face after this meeting, because I guarantee they're rethinking their entire career right now.
Okay, sound is back on at the jail, so we will go back on the record in the matter of People versus Latavius Rashad Thornton. This is case 25-0203-FY. Mr. Anid, prosecutor, and Mr. Thornton, representing himself, have met in a breakout room. So first, because the prosecutor has burden of proof, I'm going to ask Mr. Anid first, then Mr. Thornton, I'll ask you. So Mr. Anid, anything from the breakout room that you'd like to report?
Yes, I just want to make sure Mr. Thornton is there because I don't see him on here.
Oh, I see him. Do you?
Okay. Can you hear me? Okay. Yep. So we discussed. Yep. We discussed a little bit of as much as we could. I believe based on my discussions with him, I don't believe this is a competency issue. I believe this is more of the what Mr. Thornton kind of described earlier. So the plan, I think we both agreed on, is we're asking for another probable cause conference. I'm going to somehow figure out how to provide him discovery, the complaint, the information, all the charging documents that we have. We're going to come back. In the meantime, I'm going to do my due diligence to speak with our office to see how we're going to go forward with this. Because I know, it's my understanding, he wants to represent himself. That is his right. I believe based on the questions that you asked earlier, he answered them pretty fairly, Your Honor. I just want to make sure we got all ducks in order. I discussed a misdemeanor offer potentially with them, but also discussed that I encourage him to get a public defender. All these things I think we're going to discuss at the next probable cause conference. I think these are all appropriate matters so I can get my ducks in order. He can have discovery to know what he's looking at. And I believe at the next hearing, we will have a good understanding of what we're doing going forward.
Mr. Thornton, is that an accurate report?
It's pretty accurate, Your Honor. Just a few more points that we had discussed in that breakout room was also that it was in the discovery, we would like to get subject matter in the appointment of the authorities that has been filed onto the record for these proceedings and how we came about to be into the court's jurisdiction for this matter in such fashion. And I think that's kind of
that's a word salad. It's not making any soup. Can you make sense at all? Can you rephrase that for me, Mr. Thornton?
Mr. Amir, yeah. So Just pretty much all in the discovery, we didn't want any documents that have been filed onto the case to be missing, and
Okay.
that's not that's what I mean by not limited to the documents titles that he named. It include an inclusion of all documents filed under with all titles under them.
And
Okay.
I'll
Yes,
chime in
Mr.
here.
Ned.
And I think kind of what he may be talking about is, and I could be wrong, is the charging documents, what gives us the authority to proceed forward and how we're proceeding forward. And I explained you should wait until you discover it because I believe that's going to be the complaint, the information, and the other charging documents to see where we're at. I could be wrong, but once he receives those, we'll come back. We'll have all the ducks in order. I think that's a good resolution we both agreed on. And in the meantime, I'll do my due diligence to speak with our officer how we're going to go forward. I told Mr. Thornton, I'm the prosecutor. He understands what the prosecutor is. I'm not on his side, but I did advise I'm here to help get the situation resolved as fast as possible.
Commentary tone that fits perfectly for narration. One thing I've noticed about sovereign citizens, they swear up and down they want to resolve their case fast, but the second court starts, they argue like they got nothing but free time and a law degree from Google. It's like watching someone say they are starving, then spend 20 minutes complaining about the menu. Just make it make sense. This guy could have wrapped things up days ago if he just acted normal and answered a few basic questions instead of launching into another rant about natural law or whatever imaginary rulebook is following. They want the system to work for them, but only on their terms. It's like playing Monopoly and refusing to pay rent because the Constitution doesn't mention boardwalk, and honestly, if courtrooms gave out trophies for wasting time, this guy would already be on the podium holding gold. Let's get back into it and see how many more delays he can invent in the next 5 minutes. And seriously, if anyone can explain how saying, "I don't consent" helps move a case along, please drop it in the comments, because I'm genuinely lost.
And I think we both agree that if you find good cause to adjourn this for one more probable cause conference, I believe everything will be situated.
Mr. Thornton, anything further this morning?
Not at this time, Your Honor.
Just new dates.
Ned?
New dates. Our new probable cause.
Okay, so we had the dates, and that is 8:30 a.m., April 25th, for a probable cause conference, and 9 a.m., May 1st, for a preliminary exam.
Okay, so the next probable cause conference is about a month away. Does that sound right?
Yes.
Okay. All right.
So, Mr. Thornton, if at any time you change your mind, you can communicate with the court and or Mr. Anid about requesting counsel. At every hearing, I'm obligated to tell you your right about counsel and to determine the parameters of that. All right, so we will see you back at 8:30 a.m., April 25th. That is all.
Thank you, Your Honor.
Thank you.
Take care.
Thank you.
Take care, Mr. Amid.
So this is at his last hearing for now, is either taking the plea deal or going full YouTube law school and representing himself. Which honestly sounds like the pilot episode of a really bad courtroom reality show. Either way, this man manages to make me lose brain cells faster than scrolling TikTok at 3 a.m. in credit, where it's due the judge had the patience of an absolute saint. She sat there calmly trying to walk this guy through the legal process like a mom explaining how Wi-Fi works to her 80-year-old dad. I know some of you will say she was being too soft. But honestly, there's only so much you can do when logic checks out and delusion checks in. I've seen Karens with less entitlement at a return counter. And that's saying something, but what do you guys think? Should people like this even be allowed to represent themselves? Or should the court just hand them a coloring book and call it a day if you enjoyed this one? Make sure to subscribe, and stick around because trust me, it only gets wilder from here.